I just contacted the courthouse trying to schedule motion dates and conference dates. Can't get some for a couple of months now. These files need to move ahead. My clients are getting litigation fatigue. How do we resolve that? How do I recommend something? Mediation is a way to move files along without the need of litigation. So maybe I'm going to start recommending mediation a lot more now that I can't get court dates. I think that's what I'm going to do.
This episode of Off the Cuff is brought to you by Weaver Simmons, and we're very pleased to bring it to you. I hope you enjoy it.
Welcome to episode 1, season 2 of Off the Cuff. I'm Matt Butler.
I'm Dhiren.
We're back.
Finally.
Yeah, back in studio. It's been a bit.
I forgot how to do this a little bit.
Yeah, this is take 17? Nah, we're just kidding.
Yeah.
We're one take guys. Well, thanks for joining us again. We took a bit of time. A lot of work goes into the episodes we do, and we wanted to sort of take in what season 1 was, take some feedback, and try to make it better. So we're coming with a different format this year, or this season rather.
Lots of feedback from last season. You know, most of it was not so great, but it
was all right.
I know, but
it was just long.
Yeah, too long,
it was
right?
just too long.
Yeah, I guess today we can't keep people's attention. We look pretty good. I thought they would look at us for a long time, but
okay.
But no, I guess not. So anyways, we're back in with a new format. We've decided to do a couple different things this year, and starting with shorter episodes. So I think you guys are probably thrilled about that.
And what we're going to do after, so you're going to have the YouTube show. We're still going to have these on different platforms where you get your podcasts. But we're also, for the weeks after our YouTube shows, we're going to have audio-only podcasts with special guests that we either had on the YouTube show or just somebody else, yeah.
And we heard that as well as part of the feedback, that people do really like just the audio only, and you know, they consume their content in different ways. And so this season, in an effort to get out more content and I guess appease the masses,
sure,
we decided to do it this way. So you'll get a little bit of us, our flair in studio, and then you'll get a little bit of us in your ear the next week. And
there you go.
We hope that you consume all the content, because we work hard and try to make it relevant and informational, you know?
So what are we talking about today?
Well, today's episode, we've talked about this a lot, and it's become an important thing today in today's legal landscape, because a lot of litigation is ongoing for a very long time, and costs are rising, and all these things are happening, and COVID hits, and, you know, boom, the courts are closed. So mediation, alternate dispute resolution, arbitration are all forms of, I guess, ADR is what it's colloquially called in the legal context, but it's all out of court resolution. So that's what we're going to focus on today.
Yeah, and there's different areas of law where mediation is a great avenue. And anybody who doesn't know what mediation is, I like to say to clients, and I don't know if this is 100% accurate, but sometimes it could be a guided negotiation with somebody who's trained in sort of trying to get, you know, all the sort of conflict to resolution. Mm-hmm. Let's strip away the stuff that's getting in the way of resolution. And it can be a great opportunity for litigants to really keep control of where the litigation is going.
And what's really cool about mediation, which a lot of people don't know, is that the mediator doesn't make a decision. Right?
No.
So the mediator is somebody who's truly there to help you and the other side and everyone else involved come to a resolution based on what they hear in all the different rooms. And so when you hear Matt sit down with Scott later on this episode, you'll find out what that kind of looks like. But really, the mediator is somebody who will go to each party, who are all separate, and work with them and hear what they have to say, really listen in to their feelings, their emotions, and take those emotions and those frustrations and share them with the other side in a way that might elicit a response.
Yeah. So I've done it a few times now in my family practice, and you can imagine how the emotionally charged sort of litigation sometimes just the emotions get in the way of any possibility of a resolution. So in mediation, you can actually, and it's a weird, because like sometimes it gets in the way of like I said, a resolution, the emotion, but the emotions can be used to make the other side understand where someone's coming from potentially. Yeah. And actually you can almost gather empathy, sympathy between the two parties. And again, the conflict at times can just be let's take a breath and let's look at, the bigger picture. So the family context, it can actually be a great avenue.
And what's really neat in some jurisdictions in Ontario, at least, is that mediation is mandatory.
In what type of circumstances?
In civil litigation, I think there's some commercial aspects that it's mandatory in. And so in Toronto, for example, they have mandatory mediations for certain types of cases. And I think that's great. I think that you ought to have to try to resolve it out of court, just because, of course, practically speaking, court time is at an all-time premium right now.
It really is.
And since COVID, we're kind of out of the COVID era, and from the court's perspective, and we're back doing things in person. We're doing these mediations in person now, which is amazing. Mm-hmm. Your court time is so precious that having mandatory mediations and having the opportunity to sit down with the parties and even the lawyers sometimes, because you don't even get to talk to them very often anymore, or at least have that face-to-face conversation, or we've lost that because of COVID. So to get back into the room with people, it's been really helpful. And in some cases, it just worked for me. It worked out well. So that's mediation. Then there's arbitration, which is kind of like a hearing.
Yeah, a little more formal.
Yeah, it's like a hearing, and you have an arbitrator. And then negotiation, which is kind of just the all-encompassing term of ADR, where you're always trying to resolve a case. So that's kind of where we're going today, and we hope that this episode gives you that little jolt in the right direction if you're stuck in litigation and want to pursue resolution and are stuck and can't get anywhere.
Yeah. So, and we spoke to a partner in the firm, Scott Croteau, who offers mediation services. So right after this, you're going to see the interview that we had with Scott. So stay tuned.
Weaver Simmons is Northern Ontario's largest full-service law firm. For over 90 years, Weaver Simmons has provided legal advice to its clients with 3 offices in Sudbury, North Bay, and Chapleau. Our practice will try to assist you the best we can with any legal issues you may have. For more information, please visit our website or feel free to give us a call.
Thanks for joining us today, Scott.
No problem.
So why don't you tell us a bit about yourself and your practice?
Well, I've been practicing law in Sudbury since 2014. Previous to that, I was in Toronto at a litigation firm. Partner there since 2007, was involved in numerous mandatory and private mediations before having the opportunity to come home back in 2014. And now, since then, still mediating here, and been a partner at Weaver Simmons since about 4 years ago now.
That's awesome. So for the general public, why should someone choose mediation?
Well, 2 things that come to mind for me are certainty and control. No doubt that a mediation is one of the most wonderful opportunities, and probably the best opportunity that any party will get to resolve, whether it's a hearing, whether it's a trial. Your best opportunity is to sit down and have a discussion with the other side. Lawyers are very busy. You don't always have time to look at files. But on a mediation, everybody is focusing on the one case. And by doing that, with all of the attention, perhaps different parties, there's a much better opportunity to settle, in my view. You have certainty. If the case is resolved, you have certainty. You also have control. When you decide as the party to settle the case or not, it is your decision entirely. If you wait until you go to a trial where you have either a judge or a jury deciding, or if it's a hearing, then it's someone else who decides. You may not like that result.
That's great. So once I've agreed to mediate, with the other side's agreed as well, what happens next?
Well, I mean, I think you have to think about you have to think about who you want to mediate. And in terms of what happens next, you want to talk to the other side. Does the other party really want to mediate? Are there other ways that you can resolve it? Is there a pre-hearing? Is there a pre-trial? So I think once you can get an agreement with the other party that you want to mediate, then go ahead and try that. And what happens next from there is you'd want to select your mediator and then think about the timing, whether it should be before a pre-trial. Do you have a trial coming up? Do you have an arbitration coming up? All things to consider.
Right. So how does one go about choosing a mediator?
Well, in Ontario, there's a roster of mediators that you can choose from. The provincial government actually has that online. You can easily find it. Oh, wow. The other thing, that there are many, many private mediators out there. Not as many in the north, but certainly there are a lot of private mediators. How do you go about choosing them? Depends on the case that you have. You may want a mediator who has expertise in the area of law that you're dealing with. Maybe you don't. Maybe it doesn't matter to you. Maybe you want to ask around and see whether someone has used that particular mediator before and have success with that person before. The other thing you want to think about is who you're dealing with on the other side. Do you have someone who's more forceful, and do you need a mediator who can handle maybe somebody who would be a more difficult opponent, for example? It all depends on the type of case.
Right. So now on the day of mediation, we show up, whether it's in person, by Zoom. How does the day go? What happens during the mediation?
Well, whether it's by Zoom or in person, I think it's a good idea to have an opportunity to speak to the mediator. If you're the lawyer who's representing a client, you want to make sure that you speak to the mediator. Maybe you don't know the mediator, maybe you do. You want to speak to the mediator, find out what kind of experience that particular mediator has, but also not only that mediator's experience, but that mediator's knowledge of maybe opposing counsel of the opposing party. That can be always very helpful. I myself like to have discussions with counsel way ahead of time, maybe the week before.
Okay.
And I reach out to both the lawyers ahead of time, have a quick discussion, introduce myself if we haven't met before. Once you get to the mediation, then you can talk about certain things, who's there, whether there are any surprises, is everybody that you need there at the mediation present. Talk about costs, always important as well. Get that out of the way first of all.
Of course. Now, in your experience as conducting mediations and now being a mediator, is it worth it?
Oh, absolutely, it's worth it. I mean, anytime you can sit down and talk about that one case only, as opposed to the 200 files that you may have in your cabinet, it's always worth it. In this day and age, there's the ability to speak to people in person, whether it's by phone or in person, is lost. Mm-hmm. And too often we're hiding behind the email or the text. And having the opportunity to sit down and just have a off-the-record discussion, everything's privileged, is absolutely, I would encourage 100%. Now, that also may depend on who you're dealing with. Maybe you've had experience with this particular opposing counsel who may not be conducive to a mediation, and maybe you want it to go to a judge or an arbitrator instead. But overall, I would recommend it.
Now, I understand you offer mediation services as a mediator, so how can people contact you for those mediation services?
Well, you can go to the website. You can also reach out to me. You can speak to my assistant, Natasha Mongrain, as well. There's an email address for both of us there. There's also a little bit of a blurb of information on the website about me, about the mediation services we offer. The other thing I want to say is, we're in Northern Ontario, we're in Sudbury. It's a very large geographical area. There are great mediators in the South. However, the one thing that people in the North can offer, and I can offer, is one, knowledge of the people that I'm dealing with. We see the same lawyers all the time. We see the same judges all the time. Mm-hmm. So we know who we're dealing with. We understand the landscape and may be able to better handle that kind of Northern Ontario feel to a case.
That's great, Scott. Thanks for sitting down with us today. Really appreciate it.
Thank you.
If you like that sit down with Scott, tune into Off the Cuff PostScript next week, where we take a deeper dive into mediation and arbitration. It's available on Apple and Spotify.
Alternative dispute resolution, or ADR, refers to the wide variety of methods used to resolve conflicts and disputes outside the courtroom. The most common forms of ADR include negotiation, mediation, and arbitration. In ADR, parties play an important role in resolving their disputes. Unlike litigation, which will have a binary outcome, which is win or lose, in ADR, parties tailor the outcome and the dispute resolution process according to their own needs, which in turn results to saving money and speeding the settlement.
Okay, guys, I'm going to get back on my soapbox. We heard from Matt earlier that litigation fatigue plagues everyone. It's tiring, it's exhausting, and it's not fun. In Sudbury here, we don't have mandatory mediation. In many jurisdictions in Ontario, we don't. Places like Toronto and Ottawa have mandatory mediation. And my proposal to fix that is we should have it everywhere. Because as litigants, you shouldn't be scared of litigation. You shouldn't be scared of mediation. You should want to get into a room with the other party and resolve the case. Extended, strenuous litigation is no good for anyone. So as lawyers, we try to recommend alternate dispute resolution. You heard from Scott how important mediation is and how successful it can be. And so here in today's day and age, when costs are rising, people don't have money, people are struggling to try to finish a case. Sometimes the best result is often achieved through mediation. And I can tell you from experience, I just did this maybe a couple weeks ago. We had 4 lawyers in a room here at the firm. We had a mediation privately held here. The mediator helped us through the process. And what ended the case was the 4 lawyers went into a room and talked about it. And that would never have happened if they weren't here and we didn't mediate. So I urge you, if you're stuck in litigation, if you want a result, talk to your lawyer about mediation or propose it yourself. You will find that it's a great way to try to resolve a case, and oftentimes you'll get the best result the way you want, not the way a judge wants.
This episode of Off the Cuff is brought to you by Weaver Simmons, the largest law firm in Northern Ontario.
Now people know what your office looks like.
It's pretty cool, isn't it?
At least the couch area. So mandatory mediation. You think that could work across the province, right?
Yeah, I think that concept could work across the province to alleviate some of the pressure the court's facing right now.
Yeah.
I think North Bay, for example, has 1 sitting judge in Superior Court right now. All the other 2 have retired. And can you imagine what he's feeling right now, that weight and that burden that he has on him to try to get through this caseload? You know, we have judges coming in from all over the province to try to alleviate the backlog here.
That's true. Yeah.
And I think that if you force the parties into mandatory mediation now, that comes along with cost. And I think if the province would have to move to a mandatory mediation model everywhere, the government would also have to fund mediators and mediation services across the province, especially for family cases that are legal aid certificates, et cetera. If you're going to force every case to be mediated, you may have to roll it out in smaller contexts and different jurisdictions and try to do test areas. But generally speaking, I think that mandatory mediation would work. You just have to make sure that costs are not a limiting factor in that.
No, that's a great point. And even if the mediation doesn't in and of itself resolve the entirety of the matter, you can at least narrow the issues and potentially resolve sort of minor issues that come, like, because we see that in family, like there's certain, like just where the kids are going to be dropped off, like, you know, where the exchange, some of those things, if we can just hash those out, you know, earlier on in a case, we don't have to deal with these things as they progress. And like, again, we narrow the issues, and our resources as counsel can then just be, what are the main issues, the big issues that we can help resolve? Well,
and it helps in all contexts, you know, in civil litigation files where you can maybe mediate the damages. If you're having trouble figuring out what the damages are, maybe you mediate that issue and say, okay, we've agreed on damages now. And we cannot and ever agree on whose fault it was. So let's go to trial just on that issue. But we will tell the judge or the sitting jury, we've already agreed to a number. You don't have to worry about the number if we're successful or not successful. Let's just try the issue, the actual legal issue.
Then instead of having an 8-9 day trial,
have a 4-day trial. And what does that accomplish? Well, now you're saving the court resources.
Exactly.
And that is where mediation is very powerful. And you see it, of course, in the family context where, you know, focused hearings.
Yep.
So I think that is a very, very good tool that's not being used enough. And we as lawyers, as you would say, behooves us to...
It does behoove us, yes.
To do it, right? So, my soapbox is real.
Yeah, it was good. It was a good soapbox. Now, I hope you guys have enjoyed episode 1 of season 2, the new format. We're trying to have some fun with it a little bit. Along with that fun, we're doing fun giveaways this year. So tell us a bit about that, Dhiren.
So you'll have to follow us on Instagram, and you'll see our profile link below. And when the day after this episode is released, we'll announce the actual giveaway. And on that post, you'll see how you're going to win and what you're going to win. And once that's done, there'll be a follow-up post to announce the winner.
And that will be after our bonus episode next week of Off the Cuff PostScript. So after that episode, which is the audio only, we're going to announce the winner again on Instagram. So you have to tune into that episode. You don't have to, but you should, because it's going to be really good. And after that, if there's always, you can always like and subscribe. You please give us your comments. You can still send us an email at offthecuff@weaversimmons.com. Give us your thoughts of the new format, and also topics that you'd like to hear about. I'm Matt Butler.
I'm Dhiren Chauhan.
See you next time.